Hi, this is Pam Moore, publisher with MJ Biz Daily, and I'm here today with Josh Kappel, founding partner at Vicente Sederberg. Josh, we know that one of the key questions on everyone's minds in the cannabis industry is whether or not they qualify for some of the paycheck loans that are now being offered by the federal government. Talk us through how you're helping your clients understand whether they qualify.
Thanks, Pam, and thanks for having me. It's a pleasure here. So that is the big question we've been receiving from all of our clients is, do I qualify to the Paycheck Protection Program? And for those that don't know, just a brief overview is that the Paycheck Protection Program provides a loan to small businesses under 500 employees to cover 2.5 months of their payroll expenses. And then if the business keeps 90% of their employees employed or doesn't reduce salaries or rehires individuals, that loan will be forgiven. And so, for a lot of our companies or a lot of our clients, and my company too, we're looking at this like, this is a great deal. There's like almost free money from the federal government. And the difficulty, so I've been following this, on behalf of my firm and all of our clients from day one. We've been watching as this program has unfolded, from the text of the original legislation to the interim rules that were created, and it's been a little bit of a roller coaster ride on this question, like who qualifies, how do they qualify, and how do we get an answer, and what are the risks if we don't qualify? And it's like the big question you have to, the big question, there's two big questions in the Paycheck Protection Program application, that sort of like raise this question, like who qualifies? And the questions are actually really certification. You have to certify as a borrower from the program that you are eligible for an SBA loan, and that your activity, the activity your business engages in, doesn't violate any federal, state, or local law.
Uh-oh.
I was right. So there's sort of like three types of businesses, that we should think about. One is like the licensed cannabis business. They're essential businesses. They're on the front lines providing medicine to patients during these times. They're the quote plant touching businesses. It's very clear, that those businesses don't qualify. They cannot self-certify that they're not violating federal law. It's pretty clear that our whole cannabis industry still, even though it's like we oftentimes forget about it, it's like we're still violating federal law. And so that one bucket of plant touching licensed businesses don't qualify for the Paycheck Protection Program. The other easy group to think about is the hemp and CBD businesses. So the SBA has come out and said hemp businesses do qualify, to the extent that they are following federal law. And so, another good, group of clients, the ones that get the better news when they call me is, oh, you're a hemp farm. Yes, let's talk about this. Let's get some federal relief. Like the business you're engaged in is legal. And then there's everybody in between. And this includes, sort of this middle bucket includes those who are, software providers to cannabis companies, to law firms, who help out cannabis companies, to brands, to some cannabis brands that aren't like plant touching, but they're still cannabis brands. And the question is, do they qualify? And the first sort of, thing that they have to, the first sort of gatekeeper is, is like, is what you're doing legal at the federal level? And, and that's a pretty difficult question for many to ask. I think there's different arguments that, hey, you're just a compliance company, so you're not violating any federal laws, you're helping people follow federal laws. Or, you're a packaging company and you're selling packaging to all sorts of different industries. And so like, maybe there's an argument you're not violating federal laws. The federal laws are pretty broad though. Especially when it comes to money laundering laws, et cetera. But, there's some arguments that some ancillary businesses are not violating federal laws. And so that's sort of like the first piece. But then what really sort of hurt us and like hurt the industry was the night before these applications came out. The applications came out last Friday. The night before the SBA comes up with and issues their interim rules. And these rules cross-reference the old SBA eligibility rules about who qualifies for an SBA loan. And their rules are 500 some pages of different types of businesses that qualify. So it's like, gambling companies don't qualify. Certain lobbying organizations do not qualify. And they have this whole section in their rules about indirect marijuana businesses. And indirect marijuana businesses don't qualify for SBA loans. And so then the question is like, well, what's an indirect marijuana business? And what the SBA rules say is they say any business that derives any of its revenue from a direct marijuana business, that is used to support the growth, development, or enhancement of marijuana. And then it goes on to sort of explain, firms that provide specific legal advice about the operation of a cannabis company, accounting firms that provide specific advice, lighting companies, soil companies, and it makes, what I call, really, actually expressly says it. There's two exceptions that it carves out, which I'm calling like the toilet exception or the plumber exception. It says, in the rules, it says, but if you're a plumber that goes in and fixes a toilet, you're okay. Or if you're a technician that fixes a laptop, then you're okay. And so then the analysis around, around this question is like, are you a plumber or are you, providing specific services? Are your services general to the whole world, or are they like focused on the cannabis industry? And so it becomes nuanced, and that sort of clause has really prohibits a lot of companies from certifying that they're eligible. Yeah. Not necessarily applying, but certifying that they're eligible.
So a lot of those ancillaries that you mentioned, the law firms, the lighting companies, the packaging companies, don't apply because the revenue comes because they're ultimately helping the plant touching companies make money, unlike the toilet fixer.
Unlike the toilet fixer, and that's correct. And it's and it's one of those things where it really gets difficult though is, well, actually, let me say two things. Let me take a step back. One is, there are a few arguments about why maybe this rule doesn't apply, or that the SBA exceeded their statutory authority, or it's not in effect yet. There's different arguments about why these businesses should qualify. Whether or not those arguments hold up, it's hard to say. But it's pretty clear if you dig into the rules that indirect marijuana businesses do not qualify for SBA loans, including this Paycheck Protection Program that's meant to keep people employed.
So you're advising then a lot of these companies to just accept the fact that it doesn't apply to them and find other ways to grow, or is there a hope for a change coming up?
Yeah, I mean, a lot of companies already applied for these loans. They didn't realize, the certification on the application, the application is 2 pages, and the certification just certifies that you're eligible, and so a lot of folks, in this rush to apply, because it's a first come, first serve basis of this loan forgiveness money, so everyone's trying to apply as soon as possible, they just sign it. So we have, there's a lot of folks who have already applied for these loans. And now they're saying like, wow, I just certified that I'm eligible when in fact I'm not eligible. Now what do I do?
Well, now what do you do?
And, so that's like one issue. And then, and then there's this whole thought of, let's just apply, let's just apply anyways. Like, what's the worst that could happen? That's an interesting question, because there's 500,000, 1 million, 10 million of these loans that are going to be issued for $700 billion at the new, or 600 billion if this new add-on happens. Like, people are saying maybe they all get lost in the shuffle. Maybe it doesn't matter. Maybe I'll just apply and hope for the best. And maybe it's maybe that's what will happen. But it's, the difficulty is that you made a certification that you qualify for something that you don't qualify for. And you made this certification to the federal government. And so, a lot of like the licensed cannabis businesses, it's like, it's like, would you certify to the licensing authority something that's not true? Like what happens, and so there is a risk of, sort of like increased enforcement around this. What that risk actually is, it's like hard to say, and and so like some folks are saying, oh, I already applied, we'll just see what happens. And some other clients say, hey, I already applied, I'm going to withdraw the application, or I'm going to take a step back, and so there's still sort of, people are still trying to like figure out what to actually do in this situation. And the other sort of piece that's like makes this difficult is there's the Federal False Claims Act, which this is a federal law that allows state attorney, actually not a state, it's like federal prosecutors, and also like some private citizens that have a relation to the business to bring private rights of action to stamp out fraud. And so now all of a sudden there's this, these businesses have applied, certified something that maybe they didn't know that they certified. And, it's like when everything's said and done, there's this risk that people look at who applied for these loans and see if they made a false certification or not, and then like bringing a claim. So there is like this risk that's out there under the False Claims Act, and whether or not it plays out, like hopefully it doesn't, and it's like, and hopefully it's like my like conservative viewpoint on all of this is wrong, but I think there is like a risk for folks to who falsely certify something on a government loan application.
Understood. Feels like a lot of things at this moment. There's a lot of uncertainty and a lot of risks, but hopefully on the tail end, a lot of opportunity, hopefully in the longer term. So thanks for sharing all your perspectives, and hopefully we can catch up with you again in a month or two and see where things are shaking out.
And one final thing is there is, for those who don't qualify for the Paycheck Protection Program, there is an employee retention tax credit that is available only to those that haven't received a Paycheck Protection Program loan. And so for those who who qualify under that program, which doesn't have the same legality provisions or certifications, there could be some relief. So it's like, although it's like this one program has been foreclosed, there is it's like there is other relief in the CARES Act. And we are also, at Vicente Sederberg with a bunch of our allies, we're pushing for reform at the federal level, to at least allow these ancillary companies, to take advantage of programs that were frankly like government intended them to take advantage of.
Yeah, only makes sense. All right, thanks again for your time. I appreciate it.
All right, thank you, Pam. Thanks for having me.